is to test the credibility of a witness
Okay.
and the reliability of their testimony.
All right.
It's about exposing inconsistencies,
Mm-hmm.
challenging assumptions,
Okay.
and helping the jury decide how much weight to give to the witness's statements.
So it's about getting to the truth.
Exactly.
Not just scoring points.
Right.
And this applies to both expert witnesses and regular everyday witnesses.
Absolutely.
Okay. So whether it's a neighbor testifying about what they saw or a world-renowned scientist explaining complex data,
Right.
they're both subject to cross-examination.
They are.
So what makes a cross-examination effective?
Okay.
What are some of the techniques lawyers use to really get to the heart of the matter?
Well, preparation is key. Okay.
A skilled attorney will have thoroughly researched the case,
Okay.
the witness's background, and any prior statements they've made.
Okay.
They'll be looking for weaknesses,
Right.
inconsistencies, or anything that might cast doubt on the witness's credibility.
So it's like a strategic game, anticipating the witness's responses and planning your questions accordingly.
Exactly. And a good attorney will also use their questioning to control the narrative,
Okay.
guiding the witness towards certain points
Right.
or highlighting specific details for the jury.
Okay.
But it's not just about attacking the other side's case.
Oh, right.
Right.
You mentioned that cross-examination can also be used to clarify points
Absolutely.
or even strengthen your own case.
Right. For example, an attorney might use cross-examination to get a witness to admit to certain facts
Okay.
that support their own side's argument.
Interesting.
Or they might use it to provide context or additional information
Okay.
that helps the jury see the situation in a different light.
So it's a versatile tool.
Not just a weapon.
Right.
It sounds like it requires a deep understanding of not just the law, but also human psychology.
Oh, yeah.
Persuasion.
You've hit the nail on the head.
Yeah.
It's about understanding how people think,
Right.
how they react under pressure,
Yeah.
and how to frame questions to elicit certain responses.
Right.
It's a delicate balance of strategy, knowledge, and the ability to think on your feet.
And sometimes it's about knowing when to hold back.
Yes.
Yeah.
If you push too hard,
Yeah.
you might alienate the jury
Right.
or make the witness appear sympathetic.
Right. So it's about choosing your battles and knowing when to go in for the kill, so to speak.
Exactly. But there's also a fine line
Okay.
between skillful cross-examination and unethical tactics.
That's an important point. You wouldn't want an attorney resorting to bullying
Right.
or misleading the witness just to score points.
Exactly. There are rules in place
Okay.
to ensure that cross-examination is conducted fairly and ethically.
Yep.
The judge has the authority to intervene if an attorney is being overly aggressive or engaging in badgering tactics.
So it's a reminder that even in the heat of a courtroom battle, there are boundaries that need to be respected.
Absolutely.
Now, before we move on, I'm curious about something.
Okay.
We've talked a lot about how prior statements can be used in court.
Right.
And I'm wondering how cross-examination plays into that.
It's a crucial connection.
Okay.
If a prior statement is introduced as evidence, the attorney can use cross-examination to challenge the circumstances surrounding that statement.
So if a witness said something different in a police interview,
Right.
the opposing attorney could ask them about the context of that interview.
Right.
Were they under duress? Were they tired or confused?
Exactly.
Were they properly informed of their rights?
Right. Cross-examination can be used to explore the circumstances that might have influenced the witness's previous statements.
Got it.
It helps the jury understand the full picture and assess the reliability of both the prior statement and the witness's current testimony.
It's like peeling back the layers of an onion,
Yeah.
trying to get to the core of the truth.
Yeah.
It's a fascinating process,
It is.
even if it can be intense at times.
Yeah, and it's a reminder that the pursuit of justice involves a careful examination of all the evidence,
Yeah.
from witness testimony to prior statements to expert opinions. It's a complex puzzle.
Right.
And that cross-examination is one of the key tools we use to piece it all together.
Now, we've spent quite a bit of time
We have.
discussing hearsay and its exceptions.
Right.
And I'm noticing that one rule keeps coming up, Rule 403.
Right.
It seems like this rule has the potential to override
Yeah.
everything we've talked about so far.
It's true. Rule 403 is a powerful tool
Okay.
that gives judges a lot of discretion in deciding what evidence is ultimately presented to the jury.
Right.
Essentially, it allows judges to exclude relevant evidence. If its potential to unfairly prejudice, the jury outweighs its value in proving a point.
So even if something is relevant to the case, it might not make it to the jury's ears
Right.
if the judge thinks it could sway their decision in an unfair way.
Exactly. It's all about ensuring a fair trial.
Okay.
The term unfair prejudice in this context
Right.
means that the evidence might make the jury decide the case based on emotions or biases
Okay.
rather than on the actual facts and law.
So it's like a safeguard
Right.
against potentially inflammatory evidence
Yes.
that could cloud the jury's judgment.
Exactly.
So can you give us a real-world example of how this might play out?
Sure, imagine a prosecutor in a robbery case
Okay.
wants to introduce evidence of the defendant's prior conviction for shoplifting.
Okay.
While that past offense might be technically relevant to the current charges,
Mm-hmm.
it could also unfairly prejudice the jury against the defendant.
Right, because the jury might think, well, they've stolen before, so they're more likely to have stolen again, even if the current case is completely different.
Exactly. The judge would have to weigh the potential for unfair prejudice
Okay.
against the probative value of that evidence,
Okay.
meaning how much it actually helps prove a fact in the case.
Right.
If the judge decides that the risk of unfair prejudice is too high,
Oh.
they can exclude the evidence,
Wow.
even if it's technically relevant.
So it's about making sure that the jury focuses on the specific facts of the current case,
Right.
not on past actions that might not be directly related.
Exactly. And Rule 403 isn't just about unfair prejudice.
Oh.
It also covers situations where evidence might confuse the issues,
Okay.
mislead the jury, or waste time
Okay.
with unnecessary information.
So if the evidence is more likely to create a sideshow than illuminate the main points of the case,
Right.
the judge can step in and say, nope, not worth it.
Exactly. Think of it like a signal-to-noise ratio.
Okay.
The judge is trying to ensure that the jury receives a clear signal,
Okay.
the most relevant and helpful evidence, without getting lost in the noise of irrelevant or distracting information.
This Rule 403 is pretty powerful stuff.
It is.
It gives judges a lot of control over how a trial unfolds,
It does.
but it also seems like it requires a lot of wisdom and judgment on their part.
It does, and that's why Rule 403 is often the subject of heated legal debate.
Okay.
There's no clear-cut formula for applying it.
Right.
It requires a nuanced understanding of the law, the specific facts of the case, and human psychology.
So it's a reminder that the law is not just about cold, hard facts.
Right.
It's also about ensuring fairness and preventing bias from influencing the outcome.
Well said. And this balance between factual evidence and fairness is especially important when we're dealing with evidence that can be particularly graphic or disturbing,
Okay.
like crime scene photos or videos.
Yeah, I can see how those types of evidence
Yes,
could be incredibly impactful,
they can be.
potentially swaying the jury on an emotional level
Right.
rather than a rational one.
Exactly. Imagine a murder trial where the prosecution wants to show the jury graphic photos of the victim's injuries.
Good.
While those photos might be relevant in showing the nature of the crime,
Yeah.
they could also be highly disturbing and inflammatory,
Right.
potentially leading to unfair prejudice against the defendant.
The jury might be so horrified by the images
Right.
that they have a hard time being objective about the rest of the evidence.
Exactly. The judge would have to carefully consider the potential for emotional impact and weigh it against the evidentiary value of those photos. They might decide to admit only certain photos, or they might exclude them altogether if they believe the risk of unfair prejudice is too high.
So it's a delicate balance.
It is.
You want the jury to have all the information they need to make an informed decision,
Right.
but you also don't want to overwhelm them
Yeah.
with emotionally charged evidence
Right.
that could cloud their judgment.
It's a reminder that evidence is not just about presenting facts.
Yeah.
It's also about presenting those facts in a way that ensures a fair and unbiased trial.
It's fascinating how much nuance there is to this whole process.
Yeah, it is.
And I have to say, after learning about this Rule 403,
Yeah.
it's making me rethink everything we've discussed so far
Right.
about hearsay and expert testimony.
Right.
It seems like this rule has the power to trump everything else.
It's true that Rule 403 is a powerful tool,
Okay.
but it's important to remember that it's not a license for judges
Okay.
to simply exclude any evidence they don't like
Okay.
or that they think might be controversial.
Right.
There has to be a solid legal basis for their decision.
So it's not about shielding the jury from reality
Right.
or censoring uncomfortable information.
Right.
It's about making sure that the evidence presented
Right.
is both relevant and presented in a way that promotes fairness
Exactly.
and prevents undue influence.
Exactly. And that's why the rules of evidence are so complex and fascinating.
Yeah.
They're constantly evolving to ensure that our justice system remains fair, balanced, and capable of adapting to new challenges.
Absolutely.
And types of evidence.
We've delved deep into the world of evidence today.
We have.
Exploring everything from hearsay and its exceptions to the intricacies of cross-examination and the power of Rule 403.
Yeah.
It's clear that the rules of evidence are essential for ensuring a fair and just legal process.
Absolutely.
But we're not quite finished yet.
Great.
There's one more area we need to explore.
Okay.
And it's one that's full of intrigue and legal complexities.
Right.
The concept of character evidence.
Character evidence is often seen as a bit of a wild card in legal proceedings.
Okay.
It's information about a person's character, reputation, or past conduct, and its admissibility in court is carefully regulated.
It makes sense that there would be rules around this.
Yeah.
After all, you wouldn't want a jury to convict someone just because they have a bad reputation.
Right.
Or made some poor choices in the past.
Exactly. The general rule is that character evidence is inadmissible to prove that a person acted in accordance with that character on a particular occasion.
So you can't just say, well, this person has a history of dishonesty, so they must be lying now.
Right. However, there are exceptions to this rule.
Oh, I bet.
And these exceptions often create some of the most heated legal debates.
What are some of the situations where character evidence might be allowed in court?
Well, one exception is when the defendant's character is directly at issue in the case.
Okay.
For example, in a defamation case.
Okay.
Where the plaintiff is alleging that the defendant harmed their reputation.
Right.
Evidence about the plaintiff's actual character might be admissible.
So if someone is claiming that their reputation has been damaged.
Right.
The defendant might be allowed to present evidence showing that the plaintiff already had a poor reputation.
Exactly. Another exception is when the defendant opens the door to character evidence by presenting evidence of their own good character.
Oh, so if the defendant tries to paint themselves as a saint,
right,
the prosecution might be allowed to bring up some less than saintly behavior from the past.
That's the idea. It's a bit of a strategic game.
Yeah.
With each side trying to control the narrative and present the most favorable version of events.
I can see how this could get really complicated.
It can.
Especially when you're dealing with subjective concepts like reputation and character.
It can. And there are also specific rules about how character evidence can be presented.
Okay.
For example, witnesses can't usually testify about specific instances of a person's past conduct.
So you can't just parade a bunch of people in front of the jury to say, oh yeah, I saw the defendant do this bad thing once.
Right. However, there are exceptions to this rule as well.
Okay.
For example, in some cases, evidence of a defendant's prior acts of sexual assault or child molestation might be admissible even if those acts didn't result in a conviction.
That's a pretty sensitive area.
It is.
I can see why there would be a lot of debate about when and how that kind of evidence should be allowed.
There is. It's a delicate balance between ensuring that all relevant evidence is considered and protecting the defendant's right to a fair trial.
It sounds like the rules surrounding character evidence are a bit of a minefield.
They are.
With lots of exceptions and nuances to navigate.
Yes, but the core principle is that evidence about a person's character should be used cautiously.
Okay.
And only in specific circumstances where it's deemed relevant and fair.
This has been an incredibly insightful exploration of the world of evidence.
It has been.
We've covered so much ground, from the basics of hearsay to the complexities of expert testimony, cross-examination and character evidence.
It's a lot.
It's clear that the rules of evidence are crucial for ensuring that our legal system operates fairly and effectively.
They are.
But before we wrap things up,
okay,
I'm wondering if you could leave our listener with a final thought to ponder.
Sure. I think it's important to remember that the rules of evidence are constantly evolving as our society changes and as technology advances.
Right.
New types of evidence are emerging all the time.
Yeah.
And the courts are constantly grappling with how to apply existing rules to these new forms of evidence.
It's a great point. We've seen how a case like the Hinckley assassination attempt can lead to changes in the rules of evidence.
Exactly.
And I'm sure we'll continue to see these rules adapt as new challenges arise.
Absolutely. And as we encounter new forms of evidence, such as digital communications or DNA analysis, we need to ensure that the rules of evidence are applied in a way that protects both the integrity of the legal process and the fundamental rights of individuals.
It's a fascinating and ever-evolving area of law.
It is.
And on that note, we'll leave our listener with this question to ponder.
Okay.
What new challenges do you think the rules of evidence will face in the future? And how do you think those challenges should be addressed?
That's a great question to reflect on.
And until next time, stay curious and keep those legal minds sharp.
Absolutely.
Welcome back to our deep dive, everyone. We've been talking about how evidence is used in legal proceedings, and now we're going to tackle something that can be a little controversial. Character evidence.
Yeah, it definitely adds another layer of complexity.
So what is it exactly?
Well, it's basically information about a person's personality, their reputation, or their past actions.
Okay.
And the rules about when you can use it in court are pretty strict.
Right. You wouldn't want a jury to convict someone just because they have a bad reputation or made some bad choices years ago.
Exactly. The general rule is that you can't use character evidence to say that someone did something just because they have a history of acting that way.
So you can't just say, well, this person has a history of lying, so they must be lying now.
Right. You can't just assume guilt by association or guilt by past behavior. It has to be much more specific than that.
But I'm guessing, like with most things in law, there are exceptions to this rule.
Yeah, there are, and that's where things get interesting.
Okay, lay it on me. What are some of the times when character evidence might actually be allowed?
One exception is when the defendant's character is a key part of the case itself. Like in a defamation lawsuit where someone is saying their reputation was harmed, evidence about their actual character might be allowed.
Oh, so if you're saying your reputation was ruined, the other side might try to show that your reputation wasn't so great to begin with.
Exactly. It becomes about proving or disproving what's being said about the person's character.
Interesting. Another exception I think you mentioned is if the defendant themselves brings up their good character as part of their defense.
Right. If they try to present themselves as a model citizen, the prosecution might be able to bring up some not-so-great behavior from their past to challenge that.
So it's a bit of a gamble, then.
It can be, yeah. It's like opening a can of worms. Once you put character evidence out there, you're giving the other side an opening to attack it.
I can see how this could get really tricky, especially with something as subjective as character. How do you even prove someone's character in court?
Well, there are rules about how you can present this kind of evidence.
Okay.
Usually you can't just have a bunch of people testify about specific good or bad things the person did.
So it's not like a popularity contest.
Right. It's more about their overall reputation in the community or their general way of being. It's about the bigger picture, not individual incidents.
But of course, there are always exceptions, right?
Of course. When it comes to the law, there's always an exception.
So when might those rules about specific instances be broken?
One area where things get really complicated is with cases involving sexual assault or child molestation. Sometimes evidence of a defendant's past actions in those areas might be allowed, even if those acts didn't lead to a conviction.
I can see why that would be a really sensitive area.
It is, for sure. It's a tough balance between making sure all relevant information is considered and protecting the defendant's right to a fair trial.
Right. It's about weighing the potential value of the evidence against the potential harm it could cause.
Exactly. The courts have to consider all of those factors.
Now, all this talk about character evidence makes me think about something we haven't really talked about yet, technology.
Mm-hmm.
How are the federal rules of evidence keeping up with the digital age?
That's a big question and one of the biggest challenges facing the legal system today. Think about how much digital information we create every day. Emails, text messages, social media posts, online purchases. All of that could potentially be used as evidence.
It's like a whole new world of evidence has opened up, and the old rules might not always fit.
Exactly. The courts are having to figure out how to apply these traditional ideas of hearsay and authentication to digital evidence. Mm-hmm. Like, how do you prove an email or a social media post is real? How do you know a message was really sent and received by the people it says it was?
And what about privacy? How do you balance the need for evidence with people's right to privacy in this digital world?
It's definitely a tricky area. The law is always evolving, and new cases are setting precedents all the time to try and deal with the unique issues that come up with digital evidence.
This whole discussion about digital evidence makes me think about what we said before, about how one case can change how we think about things legally. Yeah. Are there any big cases about technology that have had that kind of impact on how we view evidence in the digital age?
There are a lot, but one that comes to mind is the United States versus Warshak, which was about the government accessing emails stored on servers owned by companies like Google or Yahoo.
Okay.
That case set some important precedents for how the Fourth Amendment, which protects against unreasonable searches and seizures, applies to digital communications.
So that case helped define some limits on how law enforcement can access our personal emails and other digital info.
Exactly. It's an ongoing process, but cases like this are shaping how the law works in the digital world.
And as technology keeps advancing, We're going to see even more legal challenges and changes in the years to come. Well, this has been an incredible journey exploring the world of evidence.
Yeah, we really have.
We've looked at how these rules are designed to ensure things are fair and reliable, ultimately how they help us get to the truth and make sure justice is served.
That's right. The rules of evidence are a fundamental part of our legal system.
If there's one big takeaway for everyone listening, it's that the rules of evidence are more than just a set of technical procedures.
Absolutely.
They're a reflection of how much we value fairness and accuracy in our pursuit of justice.
I couldn't have said it better myself.
And as we wrap up, here's a final thought for everyone. The rules of evidence are not set in stone. They're always changing to keep up with our values and how we understand justice.
That's a great point.
So keep learning, keep asking questions, and keep thinking about how we can make sure our legal system is fair and gets to the truth.
That's what it's all about.
And until next time, keep those legal minds sharp.